All right, with regard to the Wooney Lee evidence, were y'all able to sort out the rest of that? I don't know if there was anything left over from last night. I think maybe there were a couple of things you were still looking at.
Yes, Your Honor. So I need, and what I was going to do right now is send, there's a 10-page PDF that the state has whittled down the Instagram threads that they would be intended on using. And so I think this should be able to be emailed to all parties. So I'm going to send it to everyone right now. And if someone's email doesn't receive it, just let me know.
Okay. So I'm looking now at the state's proposed limiting instruction, which is basically just like a version of our pattern limiter for things. And it's not particularly helpful because it doesn't address any of the nuances. So if there's any way y'all could beef that up to try to address the nuances of what it is we're dealing with, I would appreciate that. Mr. Harvey.
Yes, Judge. I spoke with Mr. Atkins yesterday with regard to some of the Wooney Lee Instagrams.
Okay.
And I don't know whether that was part of what he proposed to send everybody. Mr. Atkins?
Yes, Your Honor. And Mr. Harvey's correct. This has came up before where there's a Instagram handle that is, I believe, /QUA. Okay. And so Mr. Harvey was indicating that if that portion, which it is included, that thread in the reduced Wooney Lee Instagram, if that were to get introduced to discuss, to not either a stipulation or something for the jury that, to the state's knowledge, does not believe.
Well, that's fine. Do you have a stipulation, or will you have a stipulation by the time it comes in, if it's going to come in?
Yes, Your Honor, I would like to, and I think I'd have time to speak with Mr. Harvey and also probably Mr. Matthews about that.
All right.
That's right.
Great. Thank you.
All right. Thank you.
I do have some objections to some of the Wooney Lee exhibits. Specifically, there's two. There's a picture of my client wearing a trench coat, a denim trench coat, and it's a post presumably by, yes, OG Bull is the post is under, and it says, "Ain't none more compatible than a trench, a carbon, while in the trenches." And then some hashtags, Freequay, NSLB, 2Bs, life size, and it says booking riches on the way. You know, I get that these are allegedly my client's statements. They're statements by a party opponent to deal with the hearsay issues. However, you know, in my time trying cases, the way I've always thought of it is if there's a picture, say, and there's no picture of a gun here, but I'm just using that as an analogy. If there's a picture of a gun with my client on social media, which there's no pictures of guns with Shannon, you would have to tie it to a specific crime. Otherwise, it's just bad character evidence, would have limited probative value, and it would be excluded, presumably, or my argument would be excluded under 403. You know, this is from September 18, 2020. My client's charged with a murder in 2015. He's charged with a murder in 2022. So this is not close in time to any acts of violence that my client's alleged to have committed. And I acknowledge that ain't none more compatible than a trench, a carbon, while in the trenches could be viewed as a reference to a firearm. I'm not denying that. But what's the purpose, and is it anything more than just bad character evidence that suggests my client's around firearms? I just don't see any connection to any of the allegations in this case. So that's the first objection.
All right.
And then I have one more.
What's the state's response? In what item of evidence is that?
It is in the Dropbox. I'm sorry.
Okay.
If you could help me out on that, what folder it's in.
I am pulling that up right now, Your Honor, to orient both defense counsel in the court. It should be in the two drop boxes where evidence for Rooney Lee was sent was the co-conspirator larger drop box and also the witnesses 31 through
The
60.
one that says Wooney Lee, social media. Is this Instagram or what is this?
I believe it's believe it's in the Viverito folder, perhaps in the Jamari Holmes case.
Does somebody want to just put it on Zoom for me? That might be easier.
Yes, Your Honor. I will log into Zoom.
Okay, and then I'll need to hear the state's response. I need to log into Zoom also.
Yes, Your Honor.
Or no, I'm already
I'm
there.
gonna, if the court permits, pull it up first and then.
Sure. Is it Instagram or what is it?
I believe it's the Instagram. I should be clear, Your Honor. This is it is an overact listed in indictment, but from my perspective, that doesn't change the analysis. Just because the state alleges is an overact, if they allege an overact, a post that would fail 403 analysis, I don't believe that automatically makes it admissible. Just because they chose to plead it that way, they don't get to plead their way out of the rules of evidence.
Your Honor, it is Act 115. Overt acts do not have to be crimes in and of themselves. I am
Betty knows that.
pulling up the Zoom now, Your Honor. So, Your Honor, if the court likes, the state can make argument, but the state feels that, you know, whether this is an overt act or not an overt act. Oh,
Hang on.
sorry, Your Honor.
Okay, go ahead.
Yes, Your Honor. Whether this post furthers the conspiracy or not is what the parties respectfully will be arguing to the jury. And so when and if this Instagram post gets admitted, the state has to connect it and prove to the jury that it's an overt act in terms of the conspiracy, and defense counsel, of course, can cross and argue that it's not. And so the state doesn't feel that the state at this time, unless this court wants more argument, feels that overt acts do not have to be crimes. This is Act 115. The state is alleging that this public Instagram post referencing firearms, he says in the trenches, but having firearms is something that is an overt act of the conspiracy.
All right, I'm going to overrule the 403 objection on that. What's the next one?
Make sure that I preserve 801D2E with regard, an 801D2E objection with regard to that particular statement.
All right, well, that's overruled as well, but preserved.
Thank you.
The other one, Your Honor, is it's a verse from a song performed, a very good song by my client, and it was, and this has been litigated, full disclosure, but I just want Your Honor to understand the argument because it was litigated in front of the prior judge. Mr. Stilwell in his song says, "I beat a murder rap." He was on bond. He requested a speedy trial. There was all sorts of things. He ends up on bond. It's been years since he's been arrested. He says, "I beat a murder rap, paid my lawyer $30 for that." I don't know how much he paid. It wasn't me. But somehow, when we litigated it before, "I beat a murder rap" was deemed an admission. Like, I don't know. I've asked a lot of people this. When you say "I beat a murder rap," and universally, I figured maybe it's just me that I'm analyzing it wrong. Universally, everyone said to me, No, it just means you were charged and you beat it. It's not saying that you did it
Yeah,
and
I agree
you
with
beat
that.
it.
I think-
Well, I don't know how that's an admission.
Okay, well, the jury hadn't been told it's an admission, have they?
Well, why is it admissible then? If it's not an admission, it's just a song saying, I was arrested.
It's an admission in evidentiary terms, like an admission by a party opponent. It is not, I would not view it necessarily as an admission that I committed murder and then got away with it. But that's not what we mean evidentially when we say it's admissible under the rules of evidence as an admission. It's an admission by a party opponent, which it is that. So,
Except when we've been dealing with lyrics, and these are lyrics, we've been cognizant of First Amendment.
yes, and
Right.
everybody gets the right to say whatever they want, within the bounds of the First Amendment. But if that is also something that might be able to incriminate them in some manner, then, that's the choice they made.
Okay. Well, I would just like to reiterate my objection under relevance in 403 because
All right,
historically saying I was arrested and I beat it, I just don't see the relevance of that. But I understand the court's ruling.
Okay. What else? Okay. So was there a second Wooney Lee item?
Your Honor, I think we just addressed at least the two that Mr. Schardt.
Okay, there weren't any that Mr. Ryan had
well,
issue with.
I will not speak for, they may have issue with the reduced, I just sent to the parties
He just sent it.
the,
5
that,
minutes ago.
it's the, so that they may have objections to what the state wants to.
All right, when are we
in
going to be
that.
getting to it?
I personally think he would come up tomorrow. He could technically come up today, Your Honor.
Okay, so look at it over the lunch hour.
Yes, Your Honor.
Or now, if you can, but, all right, let's just make sure that we circle back on that before.
And yes, we will have objections.
Okay.